First, the summary of the argument. A former president lacks absolute immunity from federal criminal prosecution for conduct involving his official acts. A claim of presidential exemption from a statutory limitation requires the president to identify an Article 2 basis that precludes the application of that congressional act. No presidential power at issue in this case entitles the president to claim immunity from the general federal criminal prohibitions supporting the charges. So at the outset, Jack Smith starts out by saying that a claim of presidential exemption require that the president to identify an Article 2 basis that would preclude the application of a congressional act. In this case, the criminal statutes for which he has been indicted. No presidential power at issue in this case entitles the president to claim immunity from general federal criminal prohibitions supporting the charges, which are fraud against the United States, obstruction of official proceedings, and denial of the right to vote. The president's constitutional duty to take care that the laws be faithfully executed does not entail a general right to violate them. The framers never endorsed criminal immunity for a former president. President Nixon's official conduct in Watergate and his acceptance of a pardon implied his and President Ford's recognition that a former president was subject to prosecution. Since Watergate, the Department of Justice has held the view that a former president may face criminal prosecution, and independent and special counsels have operated from that understanding. Until petitioner's argument in this case, so had former presidents. That a president enjoys immunity from private civil damages does not extend to federal criminal prosecutions. This case involves the far weightier interest in vindicating federal criminal law in a prosecution brought by the executive branch itself. A multiplicity of private civil actions would chill a presidential decision. The same concerns are not present in a criminal context. In a criminal trial, that must be brought by the executive with strong institutional checks to ensure even-handed and impartial enforcement of the law. A grand jury must find that an indictment is justified. The government must make its case and meet its burden of proof in a public trial. The courts enforce due process protections to guard against politically motivated prosecutions. Collectively, these layered safeguards provide assurances that prosecutions will be screened under rigorous standards, that no president need be chilled in fulfilling his responsibilities by understanding that he is subject to prosecution if he commits federal crimes. Federal criminal law applies to the president. Petitioner suggests that unless a criminal statute expressly names the president, the statute doesn't apply. That radical suggestion would free the president from virtually all criminal law, even crimes such as bribery, murder, treason, and sedition, is unfounded. That rule finds no support in this court's decisions, nor is it supported by opinions of the Department of Justice, which have instead construed the statutes to apply to the president unless doing so creates a serious risk in infringing on president's constitutional powers, which is not the case here. That more modest interpretive principle has no application to the crimes charged here, which pose no risk of unconstitutionally regulating the president's conduct. For instance, the established public authority exemption of certain official conduct from the criminal law, narrowing constructions of statutes to avoid serious constitutional questions, and as a backstop as applied constitutional challenges. The impeachment judgment clause does not apply here, and the impeachment judgment clause, under that clause, the president may be prosecuted. The text of the clause clarifies that an impeached and convicted president may nevertheless be prosecuted, and thus expressly recognizes that former presidents are subject to federal criminal prosecution. And the text and structure and the history contradict petitioners' assertion that the impeachment judgment clause implicitly makes Senate conviction a condition precedent to prosecution. Impeachment is an inherently political exercise not intended to provide accountability under the ordinary course of law. Marbury did not hold that a president's acts can never be examined in a court, and a host of cases from the founding to the present refute that claim. The cases on which petitioner stands for the distinct and narrower proposition that courts will not enjoin a sitting president, that principle has no application to criminal prosecution of a former president. Absence of any prosecutions of former presidents until this case does not reflect the understanding that presidents are immune from criminal liability. Established rule for judges and prosecutors that they may claim civil liability from acts but lack any corresponding criminal immunity applies equally to former presidents. By contrast, neither constitutional text nor historical practice supports applying anything akin to legislative immunity to presidents. If this court, then the next section, if this court holds that a former president is entitled to some immunity from criminal prosecution for official acts, that principle does not preclude trial on this indictment. First, the specific form of criminal conduct charged here does not justify any form of immunity. Second, the private conduct that the indictment alleges is sufficient to support the charges. Thus, even if liability could not be premised on official acts, the case should be remanded for trial with district court to make evidentiary instructional rulings in accordance with this court's decision. So that is the summary of the argument that Jack Smith makes, essentially telling the court that Donald Trump's actions were private and criminal, and there is no exemption in Article 2 that allows the president to do what the president did as alleged in the indictment, that what former President Trump did in the indictment. Now, the part that I don't read in the summary, I don't see it, and I didn't see it in the brief that much either, is that Article 2 makes an affirmative assertion that the power to conduct presidential elections, falls on Congress, the states, and electors. And because that is an express provision in the Constitution, in Article 2, which is the article in the Constitution that vests upon Congress, vests upon POTUS all these awesome rights, does not vest upon POTUS the right to interfere or conduct election matters whatsoever. So that express divestment of that responsibility to Congress electors and states takes away from POTUS in the article that gives him power the authority to conduct any sort of investigation or inquiry with state and private individuals to determine the election. That was not in any Article 2 provision. So that positive argument they didn't make, but they made the basis a claim of presidential exemption for a statutory limitation requires the president to identify an Article 2 basis that precludes the application of that congressional act. So where in Article 2 does Donald Trump have the authority to go after state authorities and then enlist private parties to conspire and convince others, and then enlist fake electors to go side and side with the actual electors and then to send them to Congress? That all of that does not fall into any Article 2 power that the president is given.